Check out carmarshal.com. The link is in the description. They help support us.
In the Circuit Court of the 11th Judicial Circuit, in and for Miami-Dade County, Florida. Case No. 17-017515 CA, 30. Civil Division. Dr. James Eric McDonough, a.k.a. Doc Justice, individually and in his capacity as an investigative journalist for photographyisnotacrime.com. Plaintiff vs. Eric Stedin et al. Defendants underscore 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 unslash. Plaintiff's verified motion for protective order from discovery to strike defendant's motion to compel as a slap and sanctions. Plaintiff, Dr. James Eric McDonough, hereafter Dr. McDonough, submits this motion for a protective order under FLAR Civ P 1.280, c, for an order dismissing defendant's motion to compel as a strategic lawsuit against public participation, hereafter SLAP, and for sanctions under 57.105, Florida statutes. Plaintiff offers the following in support thereof. 1. Co-defendant Samuel Zeskind, hereafter Zeskind, 1 states, on page 8 of the motion to compel, that plaintiff publicly stated an intent to write a book on how to harass government entities with public records requests. Subsequently, he now claims that the defendants have a right to a. abusively expansive discovery, b. dismissal of plaintiff's public records suit, and /or c. an award of attorney fees and cost to the defendants, as a matter of law. 2. Zeskind's harassment claim is patently false. The Facebook post, Exhibit A, simply stated "We won," which was written after the July 31, 2017 hearing. A following. 1. Zeskind has apparently taken over litigating this case, though he has not yet entered a notice of appearance. Comment expressed a desire that Dr. McDonough would help others when finished with his case. Dr. McDonough replied, "That's the plan. Want to write a book on how to do this and win." 3. This abusive discovery request improperly begins by asking for plaintiff's list of subscribers. See Florida's Journalist Shield Law, FS 90.5015, and the right to anonymous association under the First and 14th Amendments, NAACP v. Alabama ex rel. Patterson. 357 U.S. 449, 1958. Zeskind's frivolous and impossible to meet discovery demands were made to cover up a myriad of violations of the Public Records Act, Chapter 119, Florida statutes. Hereafter FS 119. The evidence proffered in support of Zeskind's claim lacks even an implied intent to harass, in a bold and transparent attempt to abuse this plaintiff, and his pro se status. Due to the egregiousness of these actions, discovery should not be allowed, or should be strictly limited, for defendants under FLAR Civ P 1.280, c. 1, and sanctions applied. 4. Zeskind's motion to compel makes a claim for attorney fees, and demonstrates that there is no genuine issue of material fact with respect to the elements required to sustain a cause of action, thereby violating of the law against SLAP, Chapter 768, Section 295, Florida statutes, hereafter FS 768.295. Zeskind also made the same claim to attorney fees against plaintiff in the answer he filed for the city defendants, in response to the complaint. 5. Dismissal is particularly appropriate in the instant case as it directly implicates First Amendment rights involving matters of public concern. He failure to dismiss a SLAPP suit might necessitate long and expensive trial proceedings, which, if not really warranted, would themselves have a chilling effect on freedom of speech. Time Incorporated v. McClaney, 406 F.2d 565, 566, 5th Sir 1969, Bon Air Hotel Incorporated v. Time Incorporated, 426 F.2d 858, 865. 5th Sir 1970, the stake here, if harassment succeeds, is free debate. ID at 865.2. This is the 2. A chilling effect exists when citizens are apprehensive to exercise their rights to free expression or free association, due to threat of the expense and inconvenience of litigation. See, e.g., Laird v. Tatum, 408 U.S. 1, 12-13, 1972. Bantam Books Incorporated v. Sullivan, 372 U.S. 58, 67, 1963, internal citations omitted, and Thornhill v. Alabama, 310. U.S. 88, 97-98, 1940, discussing chilling effect on free speech rights. 2. Fact in the instant case, whereas Fs. 768.295 demands quick resolution of SLAPP claims, which is an appropriate description of the harassing and defamatory motion to compel filed by Zeskind, a licensed attorney, who should know better, or maybe through experience cares not. 6. Self-censoring is a natural result of harassing and defamatory claims. 3. Bon Air Hotel Incorporated 426 F.2d at 865. If allowed unchecked, debate on public issues will become less uninhibited, less robust, and less wide open, for self-censorship affecting the whole public is hardly less virulent for being privately administered. ID 7. Our First Amendment demands that a law enforcement officer may not use his powerful post to chill or punish speech he does not like. If he does so, he may not hide behind the veil of qualified immunity. We affirm the district court's denial of Wheeler's motion to dismiss Bailey's 1983 and state law defamation claims. Bailey v. Wheeler, 843 F.3d 473, 486, 11th CIR. 2016, the same goes, or should go, for the instant defamatory claim and unlawful withholding of public records documenting such abuse to the same effect. 8. Homestead police officers began publicly retaliating against the First Amendment rights of, or defaming the plaintiff in late 2012. Plaintiff began filing records requests documenting these abuses in 2013. Subsequently, defendants have regularly and repeatedly violated Fs. 119, forcing Dr. McDonough to file suit. Presently, defendants are again violating plaintiff's First Amendment rights and again making defamatory statements against him. This time explicitly about his desire to write a book. The purpose thereof to generate false claims related to statements about this book, which is by definition free speech in connection with. 3. The defendants falsely accused Dr. McDonough with malice of repeated harassing, implying the crime of stalking, Fs.784.048, 2, through his filing of public records requests. Although the litigation privilege provides immunity from civil damages related to these libelous comments, this court should be aware of this abuse. Further, Dr. McDonough has other defamation claims active against defendants and or their colleagues, clients, employees and or contractors in 3 separate cases, 2 of which are represented by attorneys, and 1 pro se. 3 public issues. The harassing and defamatory statement, made by Zeskind, and the subsequent SLAPP claim based upon said statement, has the direct effect of chilling speech. 9. This chilling effect extends beyond Dr. McDonough, and extends to all residents and visitors to the city, now likely afraid to publicly comment or to file records requests on matters of public importance. The perception is that the defendants will feign offense in order to squelch any criticism, or records investigation, into matters regarding public affairs of the city. This raises the stakes with respect to this court's support of the public policy of this state, as articulated in both Fs. 768.295 and Fs. 119. 10. Dr. McDonough is thereby forced to turn to this court to preserve not only his rights, but by extension those of all city residents and visitors who might wish to comment or file records request upon how the city is governed. In this circumstance, there is no debate that dismissal is appropriate, and lengthy proceedings are prohibited under Fs. 768.295 and Fs. 119. 11. In this motion, Dr. McDonough argues as a matter of law, Zeskin's motion to compel is wholly unsupportable, its alleged viability singly hinging upon a false allegation of plaintiff's stated intent to harass. Nevertheless, even assuming, arguendo, that defendants were able to establish that Dr. McDonough expressed a desire to write a book on how to harass government entities with public records requests, such actions are protected under the First Amendment, and could never form the basis for any claim by the government against a citizen. 12. Additionally, Zeskin's abuse of the plaintiff through a deliberate perversion of the discovery process should not go unaddressed, and future discovery for defendants should not be had. Further, Zeskin stated that he does not have access to Dr. McDonough's personal Facebook page, but provided screenshots of comments from Dr. McDonough's personal page from 6 months ago, in another instance of untruthfulness. See Miami-Dade Home Rule 4 Charter, Citizens Bill of Rights, A. 2. An instance which also raises the possible specter of Fourth Amendment violations, consistent with Zeskin's track record, i.e. pattern of practice. Point 4. Memorandum of Law 13. Zeskin falsely claimed on page 8 of his motion to compel that he is aware of at least one instance where McDonough has stated that he intends to someday write a book on how to harass government entities with public records requests and prevail in court on the subsequent lawsuits. Zeskin then cited Fs. 119.12.3, to support his claim, that defendants should be granted abusively expansive discovery rights, that plaintiff's case should be dismissed, or that defendants should be awarded attorney fees and cost. 14. Zeskin, in a total perversion of the process, desperately attempts to flip Fs. 119 entirely on its head, while simultaneously disregarding the provisions Fs. 768.295 and rights to free speech in connection with public issues. Zeskin, as a government agent, obstructs release of public records and blocks discovery, as if he were not a government agent and these were not public records. Zeskin, then conversely, demands access to plaintiff's records as if the plaintiff were not a private citizen, and retaliates against plaintiff's First Amendment rights. Fs. 768.295, 1, reads in part, "It is the intent of the legislature to protect the right in Florida to exercise the rights of free speech in connection with public issues as protected by the First Amendment to the United States Constitution and S. 5, Art. I of the State Constitution." 2. Fs. 768.295, 2, a, reads in part, "Free speech in connection with public issues means any written or oral statement made in or in connection with a book, news report, or other similar work, 3, FS 768.295, 3, reads in part. A person or governmental entity in the state may not file or cause to be filed, through its employees or agents, any counterclaim against another person or entity without merit and primarily because such person or entity has exercised the constitutional right of free speech in connection with a public issue, and 4. C. Zeskin's unlawful glomar response to the ACLU violating FS 119, on the use of stingrays, which violated the Fourth Amendment as they were used without a warrant, S. Exhibit B. 5-4, FS 768.295, 4, reads. A person or entity sued by a governmental entity or another person in violation of this section has a right to an expeditious resolution of a claim that the suit is in violation of this section. A person or entity may move the court for an order dismissing the action. Emphasis added. 15. Further, filing records requests even if comprehensive and extensive is not harassment. Even though a public agency may believe that a person or group are fanatics, harassers or are extremely annoying, the public records are available to all of the citizens of the state of Florida. Salvatore v. City of Stewart, No. 91-812 CA, FLA 19th Sir CT December 17, 1991, see also, Curry v. State, 811 So. 2D 736, 741, FLA 4th DCA 2002, Defendant's Conduct. In making over 40 public records requests concerning victim constituted a legitimate purpose, and thus cannot violate the stalking law because the right to obtain the records is established by statute and acknowledged in the state constitution. 16. After Zeskin's repeated allegations of harassment, Dr. McDonough requested any such post or comment, where Dr. McDonough had claimed he intended to harass government, or to write a book to teach people how to harass government. Zeskin took a month to provide a screenshot of the alleged comment lacking any context or date. Dr. McDonough, after several hours, and with specialized IT help, was able to track down the original post to provide context. The post and relevant comments are reproduced below. Dr. McDonough, July 31, 2017. We won. First subscriber, congratulations. I hope this all is done for your family heart. Emoji. Dr. McDonough, it is only beginning. Second subscriber, I hope you help other people when this is over. Dr. McDonough, that's the plan. Want to write a book on how to do this and win. 617. It is painfully obvious that Dr. McDonough in no way claimed any desire to write a book on how to harass anyone or anything. Therefore, Zeskin's intent claim is based on a false premise, and was clearly and unequivocally intended to mislead this court. 18. Additionally, the post and comments were made after the July 31, 2017 hearing. As such, it would be impossible for the comment to demonstrate a prerequisite desire to harass as the motive for filing any earlier requests. Yet, the comment in context still fails to even hint at any desire or attempt to harass government. Further, plaintiff's records requests legally are not harassing as they serve a legitimate purpose, and no other allegation of frivolous intent has been proposed by defendants. The contested requests are far removed from the letter and intent behind FS 119.12, 3, and defendants' resistance is only to cover deeper crimes being committed. 19. Even assuming, arguendo, that defendant's claim is accurate, it still fails as Zeskin attempts to make a claim against Dr. McDonough for exercising his free speech as a journalist, which is inextricably intertwined with his separate right to file records requests. The Comment at issue as explicitly pointed out by Zeskind is in connection with the book. Therefore, defendant's motion to compel fails even had defendants not attempted to use deception, as it is a slap claim by definition, and prima facie violative FS. 768.295. 20. Without Zeskind's false claim of harassment, there are no legal grounds to request any information from Dr. McDonough, period. Nothing in defendant's request for production is germane to the issue of whether defendants violated FS. 119. Further, the motion to compel is just another of Zeskind's strategies to harass plaintiff and delay litigation. 21. Irrespective of the false statement, S, and slap status, FS. 119.12, 3, still would not apply as, A, it deals in attorney fees and plaintiff is acting pro se, B, the majority of requests were before the non-retroactive amendment in 2017, C, all records requests were filed for the protected purpose of gathering information on government activities related to public matters, so 7. Plaintiff could later speak on and publish said information, and to demonstrate defendants' malice in civil rights violations against plaintiff, and D, even assuming, arguendo, Zeskind's allegations to be true, an improper or frivolous purpose has not been alleged. Where improper purpose is defined as a request to inspect or copy a public record or to participate in the civil action primarily to cause a violation of FS 119 or for a frivolous purpose, FS 119.12, 3. 22. Therefore, any claims to FS 119.12, 3, under the facts of the case are wholly without merit, unconstitutional, violate FS 768.295, should be stricken, and sanctions applied for the attempt. Zeskind's motion to compel represents a complete abuse of the discovery process and a possible fraud upon this court, retaliation against Dr. McDonough's rights to free speech in connection with public issues under the U.S. and Florida constitutions, and violates Zeskind's duty of candor towards the tribunal. 5. Therefore, defendant Zeskind should be sanctioned for his unethical actions related to his frivolous, abusive, and retaliatory motion to compel, which is based upon a false premise, if assumed true still lacks a modicum of merit. Conclusion. 23. It is this court's duty to determine, as a matter of law, whether defendants have made a slap claim in response to Dr. McDonough's free speech in connection with public issues. The facts and evidence of record are objective, clear, convincing and indisputable that defendants have made false statements and claims in retaliation of the exercise of free speech. 24. Alternatively, the right to attack the motion to compel on any other legal ground or theory, whether provided herein or not, is herein preserved. This includes but is not limited to a. The physical impossibility of complying with the request, b. Florida's journalism shield law, c. Anonymous association, d. Equal or less burden on defendants to retrieve requested. 5. False evidence, duty to disclose. A lawyer shall not knowingly, 1. Make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 8. Records, e. Overbroad, f. Irrelevant, g. Harassing, and I. Oppressive. Zeskind's retaliatory motion to compel is nothing short of an abusive fishing expedition. Plaintiff has cooperated with defendants' reasonable requests, yet conversely defendants have refused, obstructed, and or unduly delayed all of plaintiff's records and discovery requests, even orders from this court. 25. Further, to any extent defendants claim for any rights to discovery past that already provided by plaintiff, dismissal of plaintiff's claims, and / or awarding attorney fees to defendants for defending this action is found valid, under FS 119.12, 3, this statute is hereby challenged facially and / or as applied as being prima facie in violation of Florida Constitution. Art. I, Sector 24, A, and / or Florida Constitution, Art. I, Sector 24, C, Point 6. Wherefore, the plaintiff, Dr. McDonough, respectfully requests this honorable court to enter judgment in his favor and take the following actions. A. Forward this motion to the Florida Bar for disciplinary review recommending action. B. Dismiss Zeskin's motion to compel with prejudice. C. Place a protective order barring all defendants from further discovery. D. Fine Zeskind an equivalent amount in attorney's fees which would be awarded, if plaintiff had been represented by counsel, i.e. the same as what the attorneys have billed since the hearing, including defense of this motion. E. Order defendants to pay all future cost of this case, including plaintiff's discovery. F. Order defendants to pay a reasonable retainer, S, for an attorney, S, for plaintiff. G. Declare attorney-client privilege between WSH and City of Homestead null and void, and forbid co-defendant attorneys from further litigating this case against the plaintiff. H. Any further relief and / or sanctions as the court deems just and proper. 6. A. Every person has the right to inspect or copy any public record made or received in connection with the official business of. This section specifically includes municipalities. C. This section shall be self-executing. The legislature, however, may provide for the exemption of records from the requirements of subsection A, provided that such law shall state with specificity the public necessity justifying the exemption and shall be no broader than necessary to accomplish the stated purpose of the law. Laws enacted pursuant to this subsection shall contain only exemptions from the requirements of subsections A, or B, and provisions governing the enforcement of this section, and shall relate to one subject. 9. Verification and signature page. As AF, and I, Dr. James Eric McDonough, hereby declare under penalty of perjury that the above facts are true and correct to the best of my ability. Further, affiant saith not James E. McDonough, AF, and State of Florida, County of Miami-Dade. Sworn to and subscribed before me this 13th day of February 2018 by Dr. James Eric McDonough. In signature of Notary Public _F Florida. 70, EE/9. Name of notary, typed, printed or stamped. Known or produced identification. Type of identification produced. Certificate of service. I hereby certify that a true and correct copy of this motion has been served by email on Counsel for Defendants, Matthew Mondale and the Office of the Florida Attorney General via email at 1. Civil SRV@MV, Oyodalavalcom as well as Certi, ed. Mail on this 13th day of February 2018. Respectfully submitted. 1/ R. James Eric C. Dunna, Pro 56. 32320 SW 199 Ave. Homestead, Florida.
County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheep up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Sheriff County Cop Watch with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me, and I'm sick of it. So I'm trying to wake people up. But my wife would love it if some, if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave a, let's say, actually, yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But, do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.